Okay, kaanim na major topic under the labor law, yung usapin ng termination of employment. Yan. Termination of employment, under niyan, pag-usapan yung security of tenure, termination by employer, saka yung termination by employee. Okay, yung mga topics under termination of employment. So, okay, security of tenure. Ano yung mga categories of employment as to tenure? Yan. Letter A, yung regular. B, casual. C, probationary. D, project employee. E, seasonal. F, fixed term. And letter G, yung work pool employee. So, isa-isayin natin. Regular employee or permanent employees are those whose work are necessary or desirable in the usual business or trade of the employer. They cannot be terminated without just and authorized causes determined by law. So, yun lang ang pwede mong paraan para matanggal sila. Just and authorized cause. Ayan. Letter B, yung casual. Casual employees is defined where an employee is engaged to perform a job insignificant to the core business of the employer. The work must be a definite period made known to both parties at the time of engagement. A casual employee is entitled to all rights and privileges granted by law to regular employees during the period of actual employment. Letter C, ikatatlo na category ng employee, yung probationary. Probationary employees are employees in the Philippines who are made to go on a stipulated trial period before transiting to a regular employee. They enjoy security of tenure during this period and may not be dismissed except for just or authorized cause or when they fail to qualify as a regular employee. So, pwede silang matanggal when they fail to qualify as a regular employee. Ika-apat or letter D na uri, yung project employee. A project employee in the Philippines is an employment for a specific project or undertaking. The duration of project will be set and determined and will be made known to both parties. Letter E, seasonal employees. Employees on seasonal employment in the Philippines will work only for the duration of the season. These workers will be temporarily laid off during off-season but re-employed when their services are needed. The employee relationship is never severed but only suspended. Okay, hindi nawawala yung employer-employee relationship, nasususpend lamang siya. Letter F, yung fixed term. Fixed term employees in the Philippines are also known as contractual employees, where they are engaged to perform a job, work, or service for a predetermined date of completion or where the employment has a specific date of termination. During this term, fixed-term employees cannot be terminated without due process and cause under the Labor Code of the Philippines. And letter G, yung work pool employees. So under the jurisprudence, the Supreme Court held that a work pool may exist, although the workers in the pool do not receive salaries and are free to seek other employment during temporary breaks in business, provided that the workers shall be available when called to report for a project. Yun ang mga work pool employees. Work pool is beneficial to both the employer and the employee, for it prevents the unjust situation of cuddling labor at the expense of capital and at the same time enables the workers to attain the status of regular employees. Yan yung paliwanag ng ating Korte Suprema sa GR number 116781. Okay, ano naman yung legitimate subcontracting versus labor-only contracting. Ayan. Paghiwalayin natin yung dalawang yan. Let's differentiate them. Yung legitimate subcontracting versus labor-only contracting. So, ito ay under the jurisprudence. No? Legitimate subcontracting, also known as job contracting or legitimate job contracting or subcontracting, refers to an arrangement whereby a principal agrees to put out or farm out with the contractor or subcontractor the performance or completion of a specific job work or service within a definite or predetermined period regardless of whether such job, work, or service is to be performed or completed within or outside the premises of the principal. Yan yung legitimate subcon. Ang conditions niyan is tatlo. So letter A, contractor carries out a distinct and independent business free from the control and direction of the principal or employer except as to its result. Letter B, the contractor has substantial capital or investment. And letter C, the agreement between the principal and the contractor or subcontractor assures the contractual employee's entitlement to all labor and occupational safety and health standards, free exercises of the right to self-organization, security of tenure, and social welfare benefits. So legitimate subcontracting is recognized by law. While labor-only contracting is prohibited by law. Under the Labor Code, labor-only contracting refers to an arrangement where the contractor who does not have substantial capital or investment in the form of tools, equipment, machineries, work premises, among others, supplies workers to an employer, and the workers recruited are performing activities which are directly related to the principal business of such employer. So, prohibited ito. Pinagbabawal ang batas. A finding that a contractor is a labor-only contractor is equivalent to a declaration that there is an employer-employee relationship between the principal and the employees of the labor-only contractor. In such case, the labor-only contractor shall be responsible to the workers in the manner and extent as if said workers were directly employed by him. Okay. Legitimate subcon, recognized by law. Labor-only contracting, prohibited. Okay, letter B na topic natin is under termination of employment pa rin. Yung termination naman by employer. Tinanggal ng employer ang iyong employment. Okay, so pag-usapan muna natin yung substantive due process. Dalawa yan, just causes versus authorized causes. Di ba sinabi, kapag ikaw ay regular employee, you can only be terminated through just and authorized causes. Ang just causes na sinasabi sa batas ay apat. Number 1, serious misconduct. Number 2, willful disobedience or insubordination. Number 3, gross and habitual neglect of duties. Number 4, fraud or willful breach of trust, loss of confidence, commission of a crime, and analogous causes. Ang authorized causes naman ay yung mga pinapayagan ng batas ay number 1, installation of labor-saving devices. So, hindi ka na nila kailangan. Number 2, redundancy. Number 3, retrenchment or downsizing, closure, or cessation of operation, and disease. Itong just and authorized causes are both subject to mandatory conciliation and request for assistance before the single entry approach desk officers. Ayun. So, itong dalawang kaso na to, kung natanggal ka through just and authorized causes, ay subject to mandatory conciliation and request for assistance before the single entry approach desk officers at the regional, provincial, or field offices of DOLE. Employees can also be terminated for violation of company policies and or grounds provided under the collective bargaining agreement. Okay. So, hindi lang pala just and authorized causes. Pag lumabag ka rin sa company policies and sa violations provided under the collective bargaining agreement. So, yung procedural due process ng termination by employer, kailangan padalhan niya yung employee ng dalawang notice o yung twin notice rule. Twin notice rule. There are 2 written notices that must be complied with in order for a dismissal based on just cause to be valid. Mga siyang krimen o kaya insubordination, mga ganyan. Letter A, a first written notice should contain, number 1, the specific causes or grounds for termination as provided under the Labor Code as amended in company policies, if any. Number 2, detailed narration of the facts and circumstances that will serve as basis for the charge against the employee. That is a general description. A general description will not suffice. Dapat nga detailed eh. And number 3, a directive that the employee is given opportunity to submit a written explanation within a reasonable period, at least 5 calendar days. Yan yung nakalagay sa unang notice na kailangan mong ipadala as an employer. And ikalawa, yung second written notice. After determining the termination of employment is justified, the employer shall serve the employee a written notice of termination indicating that, number 1, all circumstances involving the charge against the employee have been considered, and number 2, the grounds have been established to justify the severance of their employment. The foregoing notices shall be served personally to the employee or to the employee's last known address. Yan yung procedural due process pagka yung termination ay caused by the employer. At ikatlo, illegal dismissal. Ano yung mga reliefs na meron sa illegal dismissal? Ito mahaba-habang usapin ito. Under Article 295 of the Labor Code, in cases of regular employment, the employer shall not terminate the services of an employee except for a just and authorized cause by this title. An employee who is unjustly dismissed from work shall be entitled to reinstatement without loss of seniority rights and other privileges, and to his full back wages inclusive of allowances, and to his other benefits of their monetary equivalent computed from the time his compensation was withheld from him up to the time of his actual reinstatement. So ano ba itong reinstatement ito? So under the jurisprudence, the Supreme Court held that reinstatement restores the employee who was unjustly dismissed to the position from which he was removed, that is, to his status quo ante dismissal, o yung estado niya doon sa kumpanya bago yung dismissal, while the grant of back wages allows the same employee to recover from the employer that which he had lost by way of wages as a result of his dismissal. Okay. The two forms of relief are distinct and separate one from another. Though the grant of reinstatement commonly carries with it an award of back wages, the inappropriateness or non-availability of one does not carry with it the inappropriateness or non-availability of the other. The payment of back wages is generally granted on the ground of equity. It is not private compensation or damages, but is awarded in furtherance and effectuation of the public objective of the labor code. Nor is it a redress of a private right, but rather in the nature of a command to the employer to make public reparation for dismissing an employee either due to the former's unlawful act or bad faith. Ano naman ang separation pay? Separation pay has been defined as the amount that an employee receives at the time of his severance and is designed to provide the employee with the wherewithal during the period he is looking for another employment. Separation pay must be paid when termination is based on authorized causes. Ito yung mga nag-downsize ka, mga ganyan. Okay. Pag illegal dismissal, entitled ka sa reinstatement and back wages as a general rule. Pagka naman you're terminated based on authorized cause, you are entitled to separation pay. In relation to this topic, ano yung tinatawag na doctrine of strained relations? Doctrine of strained relations. So under the jurisprudence, the Supreme Court held that under the doctrine of strained relations, the payment of separation pay is considered an acceptable alternative to reinstatement when the latter option is no longer desirable or viable. On one hand, such payment liberates the employee from what could be a highly oppressive work environment. Hindi na pwedeng ayusin ang relasyon, mag-separation pay ka na lang kesa i-reinstate pa kita. Okay, damages. Pag-usapan natin ang damages in relation to illegal dismissal caused by damages in relation to termination of employment. So under the Civil Code, exemplary or corrective damages are imposed by way of example or correction for the public good in addition to the moral, temperate, liquidated, or compensatory damages. In labor cases, the court may award exemplary damages if the dismissal was effected in a wanton, oppressive, or malevolent manner. When the entitlement to moral damages have been established, exemplary damages may be awarded even though not so expressly pleaded in the complaint nor proved. Okay. Yan sinabi sa Coca-Cola Bottles Philippines Incorporated versus Roque. Nominal damages naman are small sums fixed by the court without regard to the extent of the harm done to the injured party. They are damages without regard to in name only and are allowed simply in recognition of a technical injury based on a violation of a legal right. Under the jurisprudence, the Supreme Court held that the award of nominal damages in favor of an employee in a case where valid cause for dismissal exists, but the employer fails to observe due process in dismissing the employee. Okay. May valid cause naman tanggalin siya. Hindi niya nga lang nasunod yung procedural due process. Hindi nasunod ng employer. So si employee ay entitled sa nominal o yung small sums, maliliit na damages. As to attorney's fees under the Labor Code and the Civil Code, attorney's fees may be recovered in the following instances, namely, 5 ito Number 1, in cases involving the unlawful withholding of wages. Number 2, where the defendant's act or omission has compelled the plaintiff to litigate with third persons or the plaintiff incurred expenses to protect his interest. Number 3, in actions for the recovery of wages of household helpers, laborers, and skilled workers. Number 4, in actions for indemnity under workmen's compensation and employer's liability laws. And then number 5, in cases where the court deems it just and equitable that attorney's fees and expenses of litigation should be recovered. Okay. The established rule in labor law is that the withholding of wages need not be coupled with malice or bad faith to warrant the grant of attorney's fees under Article 3 of the Labor Code. All that is required is that the lawful wages were not paid without justification, thereby compelling the employee to litigate. Ano naman yung mga liabilities ng corporate officers? Termination of employment pa rin pinag-usapan natin. Although Article 212E of the Labor Code defines an employer as including any person acting in the interest of an employer, directly or indirectly, the said article by itself does not make a corporate officer personally liable for the debts of the corporation. In general, corporations are treated as separate and distinct legal entities from the natural persons composing them. In the absence of gross negligence, bad faith, or a specific provision of law making a corporate officer liable, such a corporate officer cannot be made personally liable for corporate liabilities. Under the jurisprudence, a director or officer is personally liable only if the following requisites are present. Dalawa lang yan. Number 1, the complaint must allege that the director or officer assented to the patently unlawful acts of the corporation or that the director or officer was guilty of gross negligence or bad faith. And number 2, there must be proof that the director or officer acted in bad faith. Okay. Pag-usapan naman natin yung burden of proof on monetary claims, on illegal dismissal, and on validity of dismissal. Okay, on monetary claims, the employer has the burden of proof over number 1, salary differential, number 2, service incentive due, number 3, holiday pay, number 4, 13th month pay. Okay, yun ang kailangan patunayan ng employer yon. The employee naman has the burden of proof over number 1, overtime pay, number 2, premium pay for holidays, And number 3, premium pay for rest days. Ang onus probandi naman, yung burden of proof. Onus probandi or burden of proof naman on illegal dismissal. Ito, the employee has the burden of proof to first show that he was indeed dismissed from employment. Before the employer must bear the burden of proving that the dismissal was illegal, the employee must first establish by substantial evidence the fact of his dismissal from service. Yan ang sinasabi ng jurisprudence. On the validity of dismissal, in an illegal dismissal case, the onus probandi rests on the employer to prove that its dismissal of an employee was for valid cause. Okay. On a side note, sabi, under the jurisprudence, the Supreme Court held that in labor cases as in other administrative and quasi-judicial proceedings, the quantum of proof necessary is substantial evidence, or such amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. Okay, and our letter C topic under termination of employment is yung termination naman by employee. Kanina by employer, ngayon naman termination by employee. So merong voluntary resignation, abandonment, at yung merong preventive suspension, merong floating status, at merong retirement. Okay. So voluntary resignation is defined as a voluntary act committed by employees who knowingly dissociate themselves from their employment for personal reasons. Voluntary resignation does not cover instances where employees are forced to resign with the use of threats, intimidation, coercion, manipulation, or where dismissal is imposed as a penalty for an offense. Okay. Ano naman yun ang voluntary resignation? Yung constructive dismissal naman is a dismissal in disguise. It is a forced or coerced resignation and is considered illegal. Illegal siya under the Philippine labor laws. Ito yung mga dismissal in disguise. It is forced or coerced resignation. Ano naman yung abandonment? Although abandonment of work is not expressly enumerated as a just cause under Article 297 of the Labor Code of the Philippines, the Supreme Court cases have recognized it as a form of or akin to neglect of duty. There are two elements of abandonment. Number 1, the failure to report to work or absence without valid or justifiable reason. And number 2, a clear intention to sever the employer-employee relationship, with the second element as the more determinative factor in being manifested by some overt acts. Yan ang dalawang elemento ng abandonment. So kahit hindi siya kasama sa mga just causes, okay, nirecognize siya ng Supreme Court through the jurisprudence na siya ay bahagi ng just cause. Ano naman yung preventive suspension? Preventive suspension is an instance when the employer can place the worker concerned under preventive suspension if his continued employment poses a serious and imminent threat to the life or property of the employer or his co-workers. In case the suspension has been perceived illegal, the employee will be entitled to payment of wages during the duration of the preventive suspension. Alam mo yung mga floating status. Normally kasi sinasabi natin ganito kasi kasalanan ng employee kaya siya pwedeng mailagay sa ganitong status. So under siya ng topic na termination by employee. Floating status. Like kung narinig to sa mga police. Floating status is synonymous to temporary retrenchment of business or undertaking, thereby inevitably forcing or causing its affected employees to go on leave. It should be in accordance with the Labor Code provision on when employment not deemed terminated. Okay, hindi pa siya terminated. At syempre yung retirement. Yan yung last na term natin under termination by employee. Retirement. Employees are entitled to a retirement pay benefit based on the regulations of the Department of Labor once they reach this specific criteria. So the employee must be in the retirement age of 60 to 65 years old. An eligible retiring employee is entitled to retirement pay equivalent to at least his half-month salary for every year of service, a fraction of at least 6 months of service being considered as one whole year. So half-month salary for every year of service, a fraction of at least 6 months of service being considered as one whole year. Okay, next topic natin, a major would be management prerogative, tapos jurisdiction and reliefs, yung dalawang natitirang last major topics natin for labor laws. Tuloy ko na kaya to, parang konti na lang eh. O sige, magtungo na tayo sa 7th major topic. Tingnan natin kung marami pa ito. Dali baka kaya nating tapusin, no? 7th major topic natin yung management prerogative under the labor laws, no? Management prerogative. So under the jurisprudence, the Supreme Court held that management prerogative refers to every employer's inherent right to regulate according to his own discretion and judgment all aspects of employment, including hiring, work assignments, working methods, the time and place and manner of work, work supervision, transfer of employees, layoff of workers, and discipline, dismissal, and recall of employees. The only limitations to the exercise of this prerogative are those imposed by labor laws and the principles of equity and substantial justice. Mabigat ang management prerogative, ano? Transfer of employees. Under the jurisprudence, the Supreme Court held that transferring an employee from one place to another is not by itself unlawful. Hindi naman siya labag sa batas. It is within the inherent right of an employee to transfer or assign ulitin natin. It is an inherent right of an employer to transfer or assign an employee in the pursuit of its legitimate business interests. However, this right is not absolute. Transfer becomes unlawful where it is motivated by discrimination or in bad faith or is effected as a form of punishment or demonization without sufficient cause. The transfer of the complainant from Baguio to Lawag or to Manila is patently a demotion in the form of punishment without just cause and would cause untold suffering on the part of the complainant. Yun yung isang quote na sinabi ng ating Korte Suprema. So inherent right naman ng management at ng employer to transfer their employees. Maliban na lamang kung ito ay motivated by discrimination or in bad faith. Okay, management prerogative. Discipline. The employer's right to conduct the affairs of its business according to its own discretion and judgment includes the prerogative to instill discipline among its employees and to impose reasonable penalties, including dismissal upon erring employees. This is a management prerogative where the free will of management to conduct its own affairs to achieve its purpose takes form. The only criterion to guide the exercise of its management prerogative to discipline erring employees is that the rules and regulations on work-related policies must always be fair and reasonable, and the corresponding penalties, when prescribed, should be commensurate to the offense involved and to the degree of infraction. Okay, pag-usapan natin yung productivity and yung productivity incentives program. Productivity refers to the relation of output to input in physical and or real money terms. Productivity incentives program refers to a formal agreement voluntarily established by the Labor Management Committee containing a productivity improvement program that will promote gainful employment improve working conditions, maintain industrial peace, and result in increased productivity, including cost savings as well as productivity gain sharing program, whereby the employees are granted productivity bonuses. Ito ay ayon sa rules implementing RA 6971, an act to encourage industrial peace by providing incentives to both labor and capital. Ayan. Under the labor law, bonus is an amount granted and paid to an employee for his industry and loyalty, which contributed to the success of the employer's business and made possible the realization of profits. As a general rule, the giving of bonus is not a demandable right of an employee. It is a management prerogative and depends on the will of the employer. However, it becomes a demandable right under any of the following circumstances. Number 1, when it is stipulated in an employment contract or collective bargaining agreement. Number 2, when the grant of bonus is a company policy or practice. And number 3, when it is granted as an additional compensation and thus must be deemed part of the wage or salary. Ano naman yung change of working hours under management prerogative? Employers have the freedom and prerogative according to their discretion and best judgment to regulate and control the time when workers should report for work and perform their respective functions. However, this power must not be exercised in bad faith. Under the jurisprudence, the Supreme Court held that management retains the working hours of its employees whenever exigencies of the service so require. So, pwede ka lang mag-change ng working hour whenever exigencies of the service so require. Ang ibig sabihin ng bona fide occupational qualification. Bona fide occupational qualification. Employment in particular jobs may not be limited to persons of a particular sex, religion, or national origin unless the employer can show that sex, religion, or national origin is an actual qualification for performing the job. Under the jurisprudence, the Supreme Court reiterated the 2 factors necessary to justify bona fide occupational qualification. Number 1, that the employment qualification is reasonably related to the essential operation of the job involved, and number 2, that there is a factual basis for believing that all persons meeting the qualification would be unable to properly perform the duties of the job. Ano naman ang clearance process? Clearance. Usually pag alis ko sa trabaho, magre-retire, magre-resign, magki-clearance. Ako na nag-resign ako, nag-clearance ako eh. Okay, clearance process is a requirement imposed by the management on an employee to settle all debts and obligations, including return of company properties or documents, to be cleared of any accountability and be issued a clearance document. Under the jurisprudence, the Supreme Court held that requiring clearance before the release of the last payments to the employee is a standard procedure among employers, whether public or private. Okay, last part ng management prerogative. Ano yung limitations ng management prerogative? Number 1, law. Number 2, collective bargaining agreement. Number 3, employment contract. Number 4, employer policy. Number 5, employer practice. And number 6, general principles of fair play and justice. Hindi pwedeng maghari-harian naman, masyado yung management naman. Management prerogatives are inferior to the state police power. Such prerogatives and the exercise thereof should be without abuse of discretion. They should likewise be done in good faith and with due regard to the rights of labor. Okay, magtungo na tayo sa ating final topic ng ating labor laws. Yung jurisdiction ng iba't ibang mga ahensya at saka yung mga reliefs. Okay, pag-usapan natin yung mga mandatory conciliation, mediation. Ito yung SENA, labor arbiter, yung mahaba-haba yan. NLRC, Judicial Review of Labor Rulings, Bureau of Labor Relations, ito yung BLR, yung National Conciliation and Mediation Board, POEA, DOLE Regional Director, DOLE Secretary, Grievance Machinery, Voluntary Arbitrator, and Prescription of Actions. Dami pa, pero konti na lang kaya natin tapusin yan. Okay, letter A, under jurisdiction and reliefs na topic, yung mandatory conciliation, mediation, yung single entry approach. Yan. Single entry approach, yung SENA. Ito pa, nalito ako sa kanila. Mandatory conciliation, mediation pala ang tawag sa kanya ay SENA. Sige na. Single entry approach o yung SENA refers to the administrative approach to provide an accessible, speedy, impartial, and inexpensive settlement procedure of all labor and employment issues through a 30-day mandatory conciliation mediation institutionalized by virtue of RA 10396 on 2013. Yung itong SENA na to, itong single entry approach. By 2016 and implementing rules and regulations through the Department Order number 151, meron nang naglabas na raw sila ng 2016, was issued by the DOLE requiring the National Conciliation and Mediation Board and its regional branches as an attached agency of DOLE to establish a single entry assistance desks. Saan kaya ito mga single entry assistance desks na ito? Okay. Mga ano naman to, mga settlement procedure for all labor and employment issues. So lahat yung all labor and employment issues pwede dito sa single entry approach na ito. Okay, letter B, yung labor arbiter. Labor arbiter, ito yung mahaba. In cases where workers or employers feel like they are still not being heard even after having followed the grievance procedure, they may raise their cases to the National Labor Relations Commission o yung NLRC. The NLRC is a quasi-judicial body under the Department of Labor and Employment that is tasked, ito yung task ng NLRC, that is tasked to promote and maintain industrial peace by resolving labor and management disputes. To file a case with the NLRC, the aggrieved party must create a complaint petition that cites their cause of action. Okay. Period. All the complainants and respondents must be cited within the petition, and this petition must be signed under oath. The petition must then be brought to the labor arbiter or their respective regional arbitration branches. The aggrieved party must also serve the opposing party with a copy of the pleading along with its supporting documents. Yan. NLRC, papasa niya sa mga labor arbiter niya. Para kung i-visualize mo, NLRC, kunwari korte, depende sa branch. Yung labor arbiter, yung parang pinaka-judge dyan. Okay, jurisdiction ng labor arbiter. The labor arbiters of the National Labor Relations Commission have exclusive original and exclusive jurisdiction. So meron daw silang exclusive original and exclusive jurisdiction to hear and decide upon the cases of all workers, whether agricultural or non-agricultural. The cases that they have jurisdiction over are the following. Number 1, unfair labor practices, ULPs. Number 2, termination disputes. Number 3, if accompanied with a claim for reinstatement, cases involving wages, rates of pay, hours of work, and other terms and conditions of employment. Number 4, claims for actual, moral, exemplary, and other forms of damages arising from employer-employee relations. Number 5, cases arising from violation of Article 264 of the Labor Code. Ito yung nag-strike ka or lockout without collective bargaining agreement. Yung mga interference interference of peaceful strike, employment of a strike breaker, violence involved in picketing, mga ganyan. Number 6, wage distortion disputes not voluntarily settled pursuant to the Wage Distortion Act. Number 7, enforcement of compromise agreements when there is non-compliance by any of the parties. Number 8, money claims arising from employer-employer relationship or by virtue of law or contract. And number 9, other issues will be taken on a case-to-case basis as provided by law. Okay, so nabanggit natin yung NLRC, yung labor arbiter na under ng NLRC. Ano naman tong NLRC na to? Nabanggit na kanina, pero basahin po ulit natin. NLRC, National Labor Relations Commission, is a quasi-judicial body tasked to promote and maintain industrial peace by resolving labor and management disputes involving both local and overseas workers through compulsory arbitration and alternative modes of dispute resolution. The NLRC rules describe the proceedings before the labor arbiter as non-litigious. Subject to the requirements of due process, the technicalities of law and procedure in the regular courts do not apply in the labor arbitration proceedings. Okay, letter D, judicial review of labor rulings. Judicial review, so dinala sa korte yung labor rulings, parang ganun. So under the jurisprudence, the Supreme Court held that even if the NLRC decision has become final and executory, the adverse party is not precluded from availing of the remedy of certiorari under Rule 65 before the Court of Appeals and then to the Supreme Court via Rule 45. Pag Rule 45 kasi questions of law lang. The doctrine of immutability is not violated when a party elevates the matter to the Court of Appeals, which the latter decided in favor of said party. So, kailan ba sabi niya may remedyo ka pa rin kahit naging final and executory na. Kailan ba naging final and executory yung ruling ng NLRC? After the lapse of 10 calendar days from receipt thereof by the parties. Okay, letter E. Under pa rin tayo itong jurisdiction and reliefs. Bureau of Labor Relations. Daming mga kung ano na sa labor. No? Bureau of Labor Relations. Ito yung BLR. BLR has regional and exclusive authority on certain cases which involve unions, collective bargaining agreement, and labor disputes in organized establishments. Ano yung kanyang mandato? Number 1, National Registry of Unions and Collective Bargaining Agreements. Sa kanya pala nire-rehistro yan, no? Number 2, formulate regulatory and developmental policies, standards, guidelines, and programs. Number 3, promoting the right to organize, including collective bargaining and improvement of the income of workers and their organizations. Number 4, lead agency in workers and employers' education. Number 5, adjudicate inter and intra-union disputes. So pag may away sa within the union and sa dalawang union, sa BLR pala sila. Number 6, promotion of bipartism and tripartism. Bipartism is the agreement that cooperation between two opposing parties. And tripartism is institutionalized as a venue where the government, the labor groups, and the employer sector can come together and resolve labor and employment issues and concerns. So, pinopromote nila yung bipartism. Bipartism is the agreement or cooperation between two opposing parties at yung tripartism. Labor groups, employer groups, and the government working together. At number 7 na mandato ng BLR o Bureau of Labor Relations ay yung formulation and implementation of programs that strengthen trade unionism to achieve industrial peace. Okay, para lang alam natin, ano ba yung mga DOLE attached agencies? Sobrang dami nito eh. Biruin mo, Department of Labor and Employment, ang dami niyang attached agencies. Andiyan yung NLRC na binabanggit natin kanina. National Reintegration Center for OFWs. Employees Compensation Commission, National Conciliation and Mediation Board o yung NCMB, Overseas Workers Welfare Administration o yung OWA, Philippine Overseas Employment Administration o yung POEA, Regional Tripartite Wages and Productivity Board, ito yung nagmumungkahi kung magkano yung mga minimum wage. Number 8, Occupational Safety and Health Center, yung TESDA, at yung Professional Regulation Commission o yung PRC. Okay, letter F, National Conciliation and Mediation Board. Ito yung NCMB. Okay, under EO number 125, the NCMB absorbed the conciliation, mediation, and labor management functions of the Bureau of Labor Relations. Yung mga conciliation, wala na sa BLR, nasa NCMB na. NCMB formulates policies, develops plans and programs, and sets standards and procedures relative to the promotion of conciliation and mediation of labor disputes, administration of the voluntary arbitration program, and the promotion of other cooperative, non-adversarial, and voluntary modes of labor dispute settlements. So yung labor dispute settlement, ito yung conciliation and mediation. Arbitration decides the dispute. Conciliation and mediation's only aim is to assist the parties to reach a settlement. So yun ang kaibahan nila. Pag arbitration, nagdidesisyon ka sa isang dispute. Pag conciliation and mediation, ina-assistihan mo yung partido na mag-reach ng agreement. Kaya pag sinabing labor arbiter kanina, para siyang judge, dinidesisyonan niya yung mga issues na may jurisdiction siya, kagaya ulit ng mga termination disputes, unfair labor practices, mga ganyan na nabasa natin kanina. Punta naman tayo letter G, yung POEA, Philippine Overseas Employment Administration. Ang legal mandate niya is to establish and maintain decent employment for Filipino migrant workers, promotes their protection and reintegration into the Philippine society, and connects to the world. Under the POEA rules, any complaint arising out of recruitment violation or recruitment or violation of the conditions of license may be filed with the nearest regional adjudication office of the POEA or the Dole Regional Office, exercising territorial jurisdiction over the place where the complainant was recruited at the option of the complainant. Okay. Tama naman yun. Kung biktima ka ng illegal recruiter na taga Davao ka, ay sa Davao ka at your option para hindi ka mahirapan. Okay, meron daw appeal or petition for review. So the Dole Secretary shall have exclusive jurisdiction. Si Dole Secretary lang ang may exclusive jurisdiction to act on appeals or petitions for review of recruitment violation cases and other related cases decided by the POEA administrator. So para makapag-apila ka sa Dole Secretary, kung nagdesisyon si POEA administrator, pwede ka mag-apila kay Dole Secretary within 15 calendar days from receipt of a copy of the decision. Ang requirements ay yung notice of appeal and an appeal memorandum with the adjudication office or the Dole Regional Office. Susunod, transmittal of records within 24 hours from receipt of a seasonably filed appeal. Yung writ of execution naman shall be issued in the name of the Republic of the Philippines after the order has become final and executory. Pag naging final and executory yung desisyon ni POEA administrator at di ka na nag-apila. Okay. Di ka na nag-apila kay Dole Secretary. Punta tayo sa letter H na topic pa rin natin to ng jurisdiction and reliefs. Letter H, yung Dole Regional Director naman. Ayan. Dole Regional Director has the power to determine the existence of employer-employee relationship. Ang jurisdiction niya, okay, Number 1, small monetary claims. So recovery of wages and other monetary claims and benefits, including legal interest owing to an employee or person employed in domestic or household service or house helper arising from employer-employee relations, provided the aggregate money claims of each complainant do not exceed 5,000 pesos. Yan ang sinasabi ng Labor Code. So, small monetary claims, usually sa mga house helper yan, yung jurisdiction ng DOLE at Regional Director. Number 2, mga labor standard cases. Mga labor standard cases resulting from the visitorial and enforcement powers of the DOLE Secretary exercised through inspection and audits. Number 3, occupational health and safety violations. Number 4, union registration cancellations. Number 5, complainants against private recruitment and placement agencies for local employment. And number 6, voluntary arbitration cases submitted to them for resolution in their capacity as an ex officio voluntary arbitrators. Letter I, ano naman tong DOLE Secretary na ito? Pinakamakapangyarihan sa lahat. DOLE Secretary. The function of the DOLE Secretary is to promote gainful employment opportunities, develop human resources, protect workers, and promote their welfare and maintain industrial peace. The DOLE Secretary has visitorial powers and enforcement powers. Ano-ano yung mga nakapaloob sa kanyang visitorial and enforcement powers? Number 1, to access employers' records and premises at any time of the day or night whenever work is being undertaken therein. Number 2, to copy therefrom. Number 3, to question any employee. Number 4, to investigate any matters to determine violation of labor laws. Number 5, to issue compliance orders to give effect to the labor standards of the labor laws. Number 6, to issue writs of execution to appropriate authority for the enforcement of their orders. Number 7, to order work stoppage to any establishment that does not comply with the law. Number 8, to inquire into the financial activities of legitimate labor organizations upon the filing of a complaint under oath supported by a written consent of at least 20% of the total membership of the labor organization to be examined. Number 9, to require employers to keep and maintain employment records as may be necessary in aid of his visitorial and enforcement powers under the Labor Code. Yung mga kapangyarihan ni DOLE Secretary. At saka nabanggit na natin kanina, di ba? Pwedeng umapil sa kanya yung mga desisyon ng POEA, mga ganyan. Okay. Nabasa na natin to kanina pero nandito siya ulit. Non-interference by courts. The doctrine of non-interference by courts. It shall be unlawful for any person or entity to obstruct, impede, delay, or otherwise render ineffective the orders of the DOLE Secretary, and no inferior court or entity shall issue temporary or permanent injunction or restraining order or otherwise assume jurisdiction over any case involving enforcement orders. Hindi mo kaya, hindi nila pagdating sa jurisdiction ng enforcement ng may kinalaman sa DOLE Secretary, powers niya, hindi pwede makialam ang sino man, ang kahit na anong inferior court. Ano naman yung mga remedyo mo from the DOLE Secretary's decision or resolution? Paano naman kung demonyo pala itong si DOLE Secretary? Number 1, special civil action for certiorari under Rules 65 before the Court of Appeals. Ito yung mga grave abuse of discretion in excess, ano mga ganun, amounting to lack of jurisdiction. And number 2, yung appeal with the office of the President. Kasi alter ego siya ng Presidente. So, appeal with the office of the President under AO number 22 series of 2011. So, yan ang remedyo mo sa mga desisyon ng DOLE Secretary. Letter J, grievance machinery. Parang sa pagkakaalam ko, bawat korporasyon o even government agency may mga ganito. Grievance machinery. Under RA 6715, it provided, RA 6715 provides the use of grievance machinery as prerequisite to voluntary arbitration. Under the Labor Code, Under the Article 260 of the Labor Code, the parties are required to establish grievance machinery for the resolution of grievances arising from the interpretation or implementation of a collective bargaining agreement or the interpretation or enforcement of company personnel policies. Grievance machinery is intended to promote friendly dialogue between labor and management as means of maintaining industrial peace. So in relation to grievance machinery, magtungo na tayo sa voluntary arbitrator, letter K. Voluntary arbitrate, di ba yung labor arbiter sa NLRC, voluntary arbitrator naman sa NCMB. So yung voluntary arbitration refers to the mode of setting labor management disputes by which the parties select a competent, trained, and impartial person who shall decide on the merits of the case and whose decision is final, executory, and binding. Okay. Ito yung pwedeng napag-usapan nyo sa grievance machinery na dalhin ang mga problema nyo sa voluntary arbitrator. Letter L, prescription of actions. Ito na yung last topic natin. Yung prescription of actions under parental jurisdiction sa reliefs siya. So, prescription of actions. Money claims. Pag meron ka money claims under Article 291 of the Labor Code, all money claims arising from employer-employee relations accruing during the effectivity of this code shall be filed within 3 years from the time the cause of action accrued. Otherwise, they shall forever be barred. Pag illegal dismissal naman, 4 years from the accrual of cause of action. Pag unfair labor practice naman, 1 year nakalagay dito. Pag offenses naman under the Labor Code, 3 years. Pag illegal recruitment naman under RA 8042, magpe-prescribe siya in 5 years. Pero mabigat yung illegal recruitment involving economic sabotage, magpe-prescribe siya in 20 years. Parang heinous crime, no? Okay, ano pa ba mga ibang naisulat natin dito? Failure to remit SSS, mga side notes na lamang ito ng labor laws. Tapos na tayo rito sa jurisdiction and reliefs. These are side notes na lamang. Failure to remit SSS ng employer constitutes estafa. Okay. So, ano sabi nga rito? Okay, kailangan daw yung mga ginagawang unfair ay may kaugnayan sa union bago mo matawag ito na unfair labor practice. Ang bulverism, ito, ano ba ito? Tama ba yan? Bulverism, Bulverism happens kapag wala ng room. No more room for bargaining in good faith. Desidido na si employer sa kung anong gusto niya. Ayaw niya na makipag-usap in good faith. At bulverism ay ipinagbabawal ng batas. Surface bargaining naman, ito yung kunwari merong pinag-uusapan siya sa collective bargaining pero wala naman pala. Wala naman pala nangyayaring bargaining talaga. It is a surface bargaining. Pinagbabawal din yan ng batas. Ang feather bedding naman, ito yung may ginawa pero hindi alinsunod sa usapan. Okay. May ginawa pero hindi alinsunod sa usapan. Kunwari, walang ginawa, nang hingi lang. Parang ganun. Anyway, pwede nating i-research sa mga yan in the future. At saka, wala na lang definition dito yung equity of the incumbent. Pero baka mahalagang terms yung mga yan. Equity of the incumbent, bulverism, surface bargaining, feather bedding, at saka yung tip na bago mo masabing unfair labor practice siya, ayon sa jurisprudence, kailangan yung ginagawang unfair ay may kaugnayan sa union. At yung failure ng employer to remit yung iyong SSS contributions, i-deduct niya sa'yo, tapos hindi niya naman nire-remit sa SSS, constitutes estafa. Okay. So, God bless.